Joining us today. My name is Debbie Schaefer. I am the Director of Media Relations for Advocates for Physicians' Rights. And now I'm going to turn it over to human rights attorney Leigh Dundas.
Thank you all very much for coming out today. Today we are asking the Department of Justice and the California State Attorney General's Office to conduct in the state of California a top-down, full-scale investigation of the county health officers, medical doctors, nurses, and other licensed professionals who appear to have engaged in a multi-year campaign engineered to end-run and/or violate a multitude of federal and state laws which exist in the main to safeguard the privacy rights of the medical information of minor school children in the state, as well as coordinate any prosecutions, impositions of monetary fines, or licensure revocation proceedings against individuals found to have violated these laws. We are further asking the Department of Justice to investigate an apparent cover-up engaged in by these professionals during which they discussed how to avoid fallout from a, quote, Public Records Act request by co-opting their county council, county attorney's offices, to open permanent ongoing investigations against these minor children's medical doctors, which ongoing investigations they would, quote, just never close, because then the, quote, entire string of actions would, quote, never be revealed, plus it's got your county council protecting the actions by the attorney-client privilege. Which ruse these doctors appear to have planned to affirmatively use as a shield to camouflage their multi-year campaign against the disabled and medically compromised school children in the state, and about which ruse they then joked that if it failed, it was not cause for alarm, because, quote, it is always fun to be sued by those whack jobs. Oh. The whack jobs to which they were referring, just so we're clear, were the parents and families of the medically compromised and disabled school children whose medical files they were planning to violate and invade. At this point, I would like to provide some context. The author of Senate Bill 276, which is currently making its way through this Capitol, has garnered support from the California Medical Association, from the governor's office, from a host of other medical organizations based on one single specific set of facts, which is this. We need to handle the dirty doctors who are writing fake medical exemptions. All of the other problems identified by the bill's author, pockets of under-vaccinated or unvaccinated school children, doctors who pose a risk to their communities from leaving these pockets of school children unvaccinated, potentials for measles outbreaks, all of these problems harken back to one single set of facts, which is dirty doctors writing fake medical exemptions. Unfortunately, the set of facts upon which the bill's author has predicated his bill appears, based on the evidence recently uncovered, to be at best incorrect and at worst falsely manufactured from the campaign I just talked about. Put simply, the linchpin for SB 276, the ammunition for it, the reason we need it, these dirty doctors writing fake medical exemption, appears to be at this point nothing less, nothing more than an outgrowth of a multi-year campaign hatched by Senator Pan's physician colleagues. Can you all see that? Is my clicker working?
Nope.
Can you make it advance to the screen?
Please show their faces.
County health officers who had planned to violate federal law and gut the private medical files of innocent school children in this state. Allow me to start at what I believe, although I do not know, to be the beginning of this story. While the ink was still drying on Senate Bill 277 a few years ago, which was one of Senator Pan's first bills concerning this issue, a woman by the name of Dr. Charity Dean, who was at the time the chief health officer for the Santa Barbara County Public Health Department, took it upon herself to send to every school superintendent, every school principal, and every director of a daycare center a letter. And in this letter, she directed all of the foregoing personnel to, quote, immediately fax all medical exemptions, permanent or temporary, to the immunization program. She also appointed herself judge, jury, and ultimate arbiter of whether these medical exemptions she was asking people to fax were going to qualify under the newly passed SB 277 standards, or alternatively, if they did not do so, she would find them to be, quote, ineligible. Let me be nothing if not clear. Federal law squarely prohibits the actions taken by a campaign like Charity Dean's. I repeat, federal law prohibits the actions that were taken there. The primary federal law on point, the primary federal law on point is known as FERPA. It stands for the Family Educational Rights and Privacy Act, and it protects immunization records and medical exemptions that are part of immunization records as part of a student's educational record. Schools may only release these records for, quote, legitimate interests. And the federal government has made clear that campaigns like Dr. Charity Dean's, which involve a blanket release of this type of immunization data, violate federal law. In a case involving the Alabama Department of Education, the state health officer in Alabama ordered the release of the immunization records in that state to the Department of Public Health, taking the position that schools were allowed to share this information regarding immunizations. The federal government disagreed. They stated that neither HIPAA nor FERPA, quote, authorizes or permits the disclosure of these medical records. Also clarified was the fact that routine vaccination data, or the lack thereof, and records pertaining thereto, were not an emergency that would have triggered one of the exceptions to this rule, or otherwise allow for data mining of students' records under this law. And they went so far as to say that there was, quote, no exception to FERPA that would permit a school to disclose health or other immunization records to a state agency, such as the Department of Public Health. In short, what I am saying is that federal government and federal law say you cannot engage in a blanket release of children's immunization records, even when it is to the State Department of Public Health, and even when your state health officer is the one ordering it. Wow. Going back to Dr. Charity Dean, after issuing the above letter, she then proceeded to host a, quote, immunization roundtable, at which most of the 58 counties in California were represented by their medical doctors who had been appointed to the position of county health officer for their region. At this meeting, which was recorded, Dr. Dean verbally recapped her program that directed all of the schools and childcare facilities, and I am direct quoting right now, to send their medical exemptions, all of them, to the Public Health Department. She notably glossed over the federal law issue I just raised, gave it only passing mention in stating that her county council had helped her sidestep a federal law issue, and instead chose to highlight the extreme backlash from the community in response to her first letter, which had caused her to release a second letter on June 24th, suggesting that schools might want to redact some of the personally identifiable health information of their students before complying with her orders. But by that point, folks, the damage was done. It was the end of the school year. It appears that a lot of the schools were leanly staffed or not really staffed at all. The first letter had gone out. By the time the second letter went out, it fell on deaf ears. And for a good portion of the last 3 or 4 years, it appears that students' health files were incorrectly and in violation of federal law being sent around the state without having been at all redacted or properly redacted, and more to the point, without ever having garnered consent from the parents who were required under this federal law to give it for any release, whether redacted or not. Dr. Dean concluded her opening statements at this meeting by noting that she had been busy recruiting all of the other 57 counties in the state to follow her lead, and noting that she already had 12 or 15 participants, quote unquote, signed up, and that she was now encouraging the Health Officers Association of California to become the, quote, home base for her campaign. Encouraged by Dr. Dean's invitation, at this point in the meeting, some of the county health officers decided they were going to refine this little campaign and avoid, and I direct quote, being interfered with by the stymieing efforts of the parents of the children. Wow. These county health officers, doctors, one and all, apparently decided, in my book, I would call this an abuse of authority that was vested in them by their government positions, to create a, quote, alternative approach so that we are, quote, not subject to Public Records Act requests or FOIA requests or document demands in the context of future lawsuits and things of this nature. After stating on the record, and I quote again, that we are not wanting to expose ourselves to things that might interfere with this campaign, they were actively hatching to end-run the federal laws that prohibit this type of conduct. These doctors proceeded to analyze ways in which they could continue to pillage the medical files of the children who were disabled and medically compromised through a coordinated, systemic, statewide attack, but to be a little bit smarter about it than Dr. Dean had been in the first instance, and to hide their actions through the creation, and I quote again, of investigations that we can conduct at any time, or through cobbling together unwarranted referrals to the medical board against these children's doctors, which they noted that they, as county health officers, can make such referrals for investigations at any time. And in such a manner, the conspirators agreed that neither the children nor the parents nor the children's pediatricians would ever be able to find out about what was happening, let alone object to it. And I quote, Doctor number one, those investigations then are not subject to Public Records Act requests. Second doctor, nor are referrals to the medical board, which anyone, including us as health officers, can make a referral for an investigation. Right? You can't even ask. It's none of their business. And when they said that, they meant it's none of the parents' business then, or the attorney's business, because of course, now it's protected behind the shield of this investigation. It is, quote, none of their business. It is just an ongoing investigation. And if you never close it out, you're fine, because then it's never revealed. Two of the county health officers on the call proceeded at this juncture to take the conspiracy to invade children's private health records a bit further by noting that they could use the above investigations they were talking about commencing as a lever by which to loop in their county council, their county attorney's offices, and create an attorney-client privilege that they can then further hide behind the skirts of. And I continue to quote, because then it is never revealed. Another doctor. Plus, it's got your county council protecting by the attorney-client privilege. And if you start with county council, that's what you do. That's where you start. Because then the entire string that is attached to it becomes protected from a Public Records Act request. So there are ways of addressing this. It is very unfortunate for Charity that she stepped up and has become targeted. Thank you, Charity, for leading the way. Laughter is noted on the record at this point. Thank you for being the human shield, in other words. Yet more laughter is noted on the record. Dr. Dean, yes, well, I am not backing away. Inconceivably, in my mind at this point, the meeting actually devolved further, with one of the county health officers noting toward the end of the meeting, quote, I'm not really interested in going after the parents. There is a systems level opportunity here, and I personally would like to smoke out their physicians. Wow. At which point, around the same time on the record, another doctor chimed in, again, with the fact that if their little campaign failed, it wouldn't be cause for alarm because it is, quote, fun to be sued by those whack jobs. Again, if you missed my introductory paragraph, the whack jobs to which they were referring were the parents of the disabled and medically compromised school children in this state, that they were actively planning a conspiracy to violate federal law on point and get out their private medical records. It may be that the actions I just described are perfectly fine. It may also be that there were multiple violations of federal and or state law. And the simple fact of the matter is this: none of us will know the answer until such time as an investigation is commenced and concluded. That's right. It is not for me to say which laws were violated, if any, or what penalties should be assessed for their violations. But what I do know as an attorney in this state is that there are multiple laws that safeguard the privacy rights of every single one of your medical files in this state or anywhere, and my medical files, and your children's medical files. And the sanctions for those who are found to have violated some of these laws range from criminal prosecution to private rights of action that can be brought by the aggrieved parties whose children's rights and other rights were violated, to deprivation of all federal funding to schools that were found to have wrongly participated in such violations of federal laws. And in case you are not aware, there are 1,100 plus school districts in this state. There are more than 10,000 schools in this state. And by my count, just under 10% of all of that funding comes from the federal government. Finally, some of these laws allow for the imposition of monetary fines on the people who violated them. $2,500 in the first instance, about 10 grand if I recall correctly in the second instance, and $25,000 per violation for the third and any subsequent violation. And it is my understanding that every breach counts as a separate violation. Today, we are asking the federal government and the state attorney general's office to commence an investigation to uncover which of these laws were violated, if any, and most importantly, I repeat, most importantly, discern by whom they were violated. Yes. Further, given the nature of the conduct that you just heard about, the repeated targeting on a systemic, countywide, and possibly statewide basis of vulnerable populations, the level of intent and collusion that some of those quotes just spoke to, the fact that there appears to have been a calculated cover-up of all of this stuff that involved county counsel's office starting these investigations, so that the entire string of deeds, or misdeeds, however you want to call it, were then hidden behind county council. And given the fact that those engineering the campaign should have known better, because they are doctors in this state. And by the way, they are not just any doctors, they are doctors who we entrusted and were appointed to one of the top spots in the state by which they were supposed to be safeguarding the citizens in their communities, not hunting them.
That's right.
And finally, given the dehumanizing speech, the dehumanizing behavior, and what I can consider as nothing less than hate speech that was directed by these doctors against the targeted children and their families, many of whom, as you well know, fall into a federally protected class of disabled children, we are asking the Department of Justice and the State Attorney General's office to impose all warranted sanctions for any violations found to the children. To our knowledge, Dr. Dean was never investigated for her role in the above scheme. Instead, and rather inconceivably, she was rewarded. She was appointed by former Governor Brown to one of the top spots in this state for medical professionals. She was appointed to the Assistant Director of the California Department of Public Health, where she still sits. If an investigation determines that either she and or her county health officer colleagues indeed behaved inappropriately, we are further asking the federal government and the state government for her immediate removal from this post. And additionally, for the removal from their post of any county health officers, doctors, one and all, who were found to have participated in this nefarious scheme that involved hate speech and targeting disabled populations. It may be that this scheme to wrongly enforce Dr. Pan's Senate Bill 277 was solely and simply a creation of Dr. Dean. Wow. It is also possible that she was not alone in hatching this plan. And that is why we are also asking the federal government today to subpoena all emails and other communications between Dr. Charity Dean and the State Medical Board, between Dr. Dean and all California legislators, particularly the legislators on whose bill she was working so zealously to enforce, the co-authors and authors of SB 277, to determine if indeed she was acting alone or if in fact she was not acting alone, and this was occurring at the behest of any other individuals or state agencies. We are also asking for an immediate notification to every single family whose child or children were found to have been subjected to this campaign or whose information was breached, so that they may quickly proceed with all avenues of redress that may be available to them. And we are additionally asking for an investigation of every medical board complaint filed since 2015 against any doctor writing a medical exemption to determine if these complaints were fruit of the proverbial poisonous tree. The facts brought to light today may well explain why there have been over 100+ investigations of doctors writing medical exemptions that were referred to the medical board, and yet not a single one of those was found to have involved wrongdoing. A couple of other things to mention. The first of which is this. It has become readily apparent as of right now that the state of California cannot, I repeat, cannot be entrusted with a database. Particularly given that California Department of Public Health, as we all know, is the one who's supposed to be in charge of rolling that database out, and Dr. Dean still sits in a controlling position on that entity. Even well-orchestrated databases designed with the best of intentions and run by honest people can be breached. We simply cannot have children's names, children's addresses, their parents' names and addresses, their schools' names and addresses, and their doctors' names and addresses warehoused and sitting around in a database that any clever pedophile or angry ex-spouse or other not good person can hack into and commit harm against that child, especially when there is no reason for it. We should not be targeting the children in the state. If we have a problem with dirty doctors, we should be targeting the doctors. That's right. And now that we know that the database component of SB 276 appears to have been a simple outgrowth of all of the stuff I just mentioned, it is a bit, in my mind, like asking the wolf to guard the henhouse. Let me be nothing if not clear. The state of California just lost the ability to claim any valid reason to warehouse these children's medical records, and sure as shooting, they have lost the ability to claim that they can be trusted to honestly carry out that task without having it devolve into a campaign to unfairly target disabled and medically compromised children, or to quote from the scheme above, smoke out physicians and target the whack job families. Second, in the absence of the data revealed here tonight, this afternoon, the amendments suggested in recent days by Governor Newsom's office, by way of social media, might have been a good start at reforming this bill. But by the time the final language hit, as we all know, this bill is pretty draconian in its current form. It forces doctors to sign documents under penalty of perjury. Moreover, it holds doctors to a guilty until proven innocent standard by which the merest whiff of an allegation or a referral to the state medical board will stay the hand of that physician from practicing in this realm for up to 2 years. He is guilty until proven innocent. Guys, we don't do this to drug dealers in this state. Why we are doing this to physicians, there are no words. Correct. Particularly now that we know that so many of these investigations were probably started from less than honest and compelling reasons. The simple fact of the matter at this point in time is that no amount of amendments, no amount of companion bills can salvage this bill, because the combination of overly harsh language in the bill on top of what we now know has been a multi-year campaign to target the doctors and open ongoing investigations that they never close and refer them, probably in an unwarranted fashion, to the medical board, has had the desired effect. It has not just chilled medical exemptions in this state, it's darn near killed them. Well, the bill's author has been busy telling all of the parents in this state that if their child needs a valid medical exemption, he or she can get one. And while that bill's author has simultaneously been telling every legislator in the Capitol behind me that same data, the fact of the matter is that parents know that this was not true. And so last week, some of these parents of disabled and medically compromised children in this state, they spent one day, calling dozens upon dozens upon dozens upon dozens upon dozens of doctors' offices in the state that collectively represented, I can't remember the exact number, but I believe it was about 800 physicians. Every single call began with, "This is a recorded line," so that they were complying with the state law in point. The parents explained to the doctors' offices that they were new here. They explained that their child had suffered an anaphylactic shock reaction in response to a vaccine, and that they knew that they needed a medical exemption now that they're here in California. As we all know, anaphylaxis is one of the only two recognized reasons for a medical exemption under the CDC guidelines, which the current bill is tied to. And do you know what these parents heard time after time after time after time after time?
No.
Correct.